Attorney Tim Williams answers your most frequently asked questions.
We're one of the few firms that handle child sex abuse cases, and I think we're one of the few firms that handle that because the subject matter is awful on everybody involved, the family member, obviously the victim, and frankly the lawyers involved as well. I mean, no one's happy to deal with this subject matter, but we see our role in the community as the protector of children, and if we can prevent these events from happening to another child through our action, through making it known in the community that if you do these awful events, these awful things to children, you will be held accountable, not just in the criminal context, but also in the civil context. I'd like to think that creates a deterrent effect and will prevent any further actions that are similar in nature to that. So with that being said, the approach we generally take is to work hand in hand with law enforcement. Usually these events are immediately reported to law enforcement, and if they're not, we report them immediately or have the family report them immediately, because it's very important for law enforcement to be involved, to gather proper documentation, to gather witness statements, to gather the evidence while it's still fresh, because things are often hidden and destroyed intentionally when it comes to crime and crime victims. For obvious reasons, people don't want to get in trouble, they realize they made a mistake, and they're trying to destroy evidence that they did the acts that they did. So law enforcement is really, really key to that. And once law enforcement's involved, it generally goes to the DA's office, district attorney's office, or the federal prosecutor's office, and then they take over from there and they prosecute the bad individual. Usually what we are forced to do is we sit on the sideline at that point. We're gathering records on behalf of the child. We're forming their civil claim in terms of building the blocks necessary to move that forward when the time is right. But we don't like to get involved and go out and file a civil lawsuit if we can at all avoid it when the criminal prosecution is ongoing, because we don't want to step on the criminal prosecutor's toes and create headaches for them in their process, because I'm a big believer that the criminal process needs to take place with as little interference as possible. Once that's wrapped up, or if there's a timing issue we have to file before that is wrapped up, we generally file the civil lawsuit, and we then gather requests and gather the investigative reports from law enforcement and the DA's office, and that gives us a big leg up in terms of the who, what, when, where, and how of the case, in addition to what we've already gathered on our own through our own independent investigation, and so on and so forth. The timing of it is a little unusual. So when you're dealing with a minor involved in a bad act such as sex abuse, they generally, for assault and battery, those are the two main causes of action in this type of case. The statute of limitations for adults in those two claims is 2 years from the date of the bad act. A minor that statute of limitation can be tolled or paused up to a total of 5 years, but it depends on the age of the minor, and the calculations really more than I would prefer to get into it, at least on this video clip. But they can be tolled. So the minors can have up to 7 years to file their assault and battery claims. In addition to that, there is a statute called the Abuse of Vulnerable Persons Act, and it's really a statute that is designed to prevent abuse of people that cannot defend themselves. So it's really geared towards very, very, very young children, like infants, or very, very old people. But we're focusing on infants and young children for the purposes of this video. Under the AVPA, and that's the acronym for that act, the child would have 7 years to file their claim, and that could potentially be tolled as well. So it gives additional time depending on the age of the child. But for lack of better purposes, let's just assume it's 7 years, because that's the hard and fast. You definitely have at least 7 years if you're a child who's abused and you're bringing a claim under that act. Additionally, there's another statute. It's a child abuse statute, and if the child is the victim of child abuse, and sexual abuse is certainly a form of child abuse as defined in the law, then the person actually has a much longer time period to file. They have until age 40 to file that claim. Age 40. So you can have up to 40 years depending on the age of the child. Or if there's the causal connection between their damages, so what they're suffering, and the event itself, i.e. the abuse, is not discovered until after age 40, they have 5 years from the date of discovery to file their claim. So they can be 60 years old, not realize that for all their lives, their PTSD symptoms were stemming from child abuse that they somehow blocked out, but they just now come to the realization that that had occurred. Then they would have, if they're 65 years old when they have that realization, they have to age 70. So child abuse itself, you have a very long timeline in terms of filing claims for child abuse. So these are all the various timelines we have in the back of our heads when people come to us and say, hey, my child was horribly abused, or I was abused as a child, or anything along that continuum. We're trying to figure out, okay, what claims are there? How long do we have to file those claims? What's been done in the criminal context? What do we know in the criminal context? What's been done in terms of police investigation, and so on and so forth? And then we try to, we don't try, we make sure that the person's claims, whatever claims are viable and still alive and still actionable when they come to us, are preserved by way of either resolving the case directly with the bad actor or filing the lawsuit and then going through legal channels to find resolution through the courthouse. So in addition to all that, in terms of just preventing child abuse, we also work with local organizations that support families and victims of child abuse. We offer support legislatively for laws that better protect families and victims of child abuse. And we work to a certain extent like a PSA, a public service announcement. We try to make it known that, hey, not only should you know these are bad acts, but also know that, and not only do you know you can be held criminally liable for these bad acts, but just know that there's a large civil hammer hanging over your head as well. And most people don't think about that. They think, oh, I'm going to go do something awful to this little child. Maybe I'm risking some years in prison for it. But they're not realizing that they can be left without house and home as well, because they've now created a giant civil liability for themselves and potentially, depending on the circumstances, their employer if it was an on-the-job issue, and there is some liability in the employer itself. So we take it very seriously, and we are huge proponents of protections for child abuse victims, and huge proponents for law enforcement in prosecuting these people that commit such acts.
If you've been injured and need help, Dwyer Williams Cherkoss Attorneys will get you the settlement you deserve. Experience gets results.